My name is Katie Sundstrom. I'm an attorney with the law firm of Lorance and Thompson PC in Houston, Texas. Today I'm going to be talking a little bit about copyright law, what copyright law means to authors and artists who need to protect their work when they're publishing it online or in other mediums. Before we talk about that, I need to talk a little bit about what copyright is and how it's created. Copyrightable subject matter is basically created once an original work of expression is fixed in a tangible medium of expression. And throughout this talk, I'm going to use a photograph as an example of an original work. So the copyright is created right when the photograph is fixed. So right when the shutter closes, right when the imprint is made on the film, your copyright is created. So what do you get with that copyright, that instant copyright? You get several things that are given to you through the Copyright Act without doing anything. You have the exclusive right to copy your photograph, to distribute your photograph, to display your photograph, and to make derivative works from your photograph. Now, what people sort of refer to this as is your bundle of rights. And I like to refer to it as a bundle of sticks. And you can do with your bundle of sticks what you want to do. You can give away the right to copy. You can give away the right to copy with a condition that you'll give attribution to you or to the author. You can give away all the rights to copy, distribute, or display your work, but keep the right to make derivative works so that anybody can take your photograph, redistribute it, make copies of it, but they have to come to you if they want to change it or make changes to it. Some authors also require, or photographers require, that you put attribution if you're going to redistribute a photograph so that they'll always know, or your audience will always know, that it was you that took that photograph, no matter how many times it's copied or distributed. There are many ways that you can protect your bundle of rights. One of the first ways is through a copyright provision in contracts. So say you're a photographer, you're a wedding photographer, and you need to put a copyright provision in all of your client contracts so that you can control how many copies are made, whether they come to you for prints, things like that. And many of the photographers unions and things like that, photographers organizations, have model agreements that you can use to go by. Another way is through useful licensing tools such as creativecommons.org. They have various licenses that allow you to freely distribute your work but still get attribution, and they have a way to link it back to the license such that there's an icon on your image. They click on the icon and they see the license, so they know exactly what they're getting, exactly what they can do with your photograph. And a very important way, probably the most important thing that I like to tell people, is to get a copyright registration. This gives you many different options and many different protections that you don't normally get just from having it fixed in a tangible medium of expression and having the birth of your copyright. And we'll go over that in a minute. Another way is to put copyright notices on your distributed and digital images, anything that you're publishing, just so that people are on notice that you consider that your copyrighted work and that you consider that your exclusive copyrighted work. Another way is to use the DMCA to send out takedown notices and other things when you do find out that somebody is misusing your work and copying it and not giving you attribution for it. So, as I said, the most important thing to me is to protect your bundle of rights with a copyright registration. It's very easy to get a copyright registration. It's very cheap to get a copyright registration. There's two ways that a photographer, for example, can get a copyright registration. One way is to go to copyright.gov and download the physical form, and for a copyright registration it would be Form VA. And you fill it out, you send it in, you pay your $45, you have to send in, and there's very specific instructions on copyright.gov how to do this. They are very friendly to the DIY copyright register. And the most simple way to do it is to fill out the digital form. Right when you go to the front page of copyright.gov, there is an icon in the right-hand corner, and if you click on that icon, it will take you through specific and easy to follow instructions for filing Form CO. And you can use that form for any form of copyrightable work. And you can even upload your specimens of that work while you're doing that straight from your computer. There's no other separate way of doing it. And you can input your credit card information and do the whole registration over the internet. It's very convenient, it's very easy, and there's no reason you shouldn't be doing it. So what does a registration do? Why would you want to take that trouble, which isn't really a lot of trouble? Why would you do that? Well, first of all, it's constructive notice to the world that you have rights in this work, in your copyrightable work, or your photograph is the example that we're using today. It gets you more statutory protection. So although the Copyright Act does delineate the rights you have once that shutter closes, once that copyright is created, you get more rights if you have a registration. One of those rights is the right to bring suit for copyright infringement. If you created the work in the US, you have to have the registration before you file suit. If you want to obtain attorney's fees, you have to have that registration. If you want to get statutory damages, minimum and maximum statutory damages require that the work is registered before the infringement even takes place. Another, especially if you're creating a lot of content, you're publishing a lot of digital photographs or anything else on a regular basis, you need to have a 3-month schedule that you're re-registering your content, re-registering your work, because that gives you the right to go back. If the infringement took place during that 3-month window, the statute makes it so that you can still capture your statutory damages, your attorney's fees, and your damages for willfulness that took place during that 3-month period. So it's sort of like your safe harbor period. Another way that I stated that you need to protect your bundle of rights is through a copyright notice. Now, a copyright notice is not required to obtain any of the rights that I talked about under the Copyright Act that you get through registration and through the creation of your copyrighted work. But it's very useful to avoid infringement by others, because it's sort of like a beware of dog sign. It puts them on notice that you do believe that this is your work, you will enforce it, and it's sort of like a warning sign. And you can use this in a way that is instructive to other people who want to use your work. You can even embed in your notice what you want them to do with your work. You could say all rights reserved, do not use at all, or you can say all rights reserved, but if you want to use it on your work, contact this email address. Or you can use the Creative Commons licensing that I spoke of before, and you can find that at creativecommons.org. Now I want to talk about some of the myths of copyright and dispel those myths. The first one is that people will respect your bundle of rights when you're publishing online. It's not necessarily true. Some people have this mentality that anything they see on the internet is theirs for the taking and they can copy it at will. There's even a faction of people that I've heard about that believe that once it's published on the internet, it loses any copyrightability, which is not true. So taking the steps that I've talked about today will ensure that protection and protect you against the people who won't necessarily respect your copyright. Another myth is the poor man's copyright, which is some people believe that they get some kind of enhanced copyright rights by mailing it to themselves, sticking in an envelope, having the date on it, and not reopening the envelope. That is useful, sort of. It sort of puts a date on the time that it was created or the date that it was created, but there's really no statutory protection, no enhanced protection by mailing it to yourself. Another myth that I've heard is that copyright notices are offensive, that, you know, the Circle C with your name is sort of invasive, that it's accusatory, that, you know, that it makes the photograph ugly. Well, I think people who think that are going to misuse your work. So you need to keep that on there when you can. If that's something that you feel strongly about, you can remove it, but copyright notices are not offensive. They tell people what you want to happen with your work. They tell people that you believe your work should be copyrighted, and it's an important way of getting that across. So basically, the desire to not offend the public does not outweigh protecting your rights. Another myth is that photographing a painting or other visual work like a sculpture would circumvent the copyright law. That's not true. When you make a derivative work by taking a photograph of a sculpture, or you make a copy of a painting by taking a picture of it, that's still violating the copyright law. And a final myth is that making a painting based on a photograph is circumventing the copyright law. That's not true either. The statute is very clear that if it's significantly similar, then it can be considered a copyright infringement. So even just painting from a copyrighted photo can be copyright infringement. So I hope you've learned a little bit about copyright law today, and that you'll take steps to protect your work instead of just leaving it up to the goodwill of other authors and internet users to respect those rights, because it doesn't always happen that way. Thanks. I'm Katie Sundstrom with the law firm of Lorance and Thompson, PC.